Good evening, everyone. Hope you're all having a lovely Thursday evening. My name is Alex Lucifero. I am an employment lawyer with Samfiru Tumarkin LLP. I manage the firm's Ottawa office, coming to you live this evening from a balmy Ottawa, Ontario. It's been beautiful weather here in Eastern Canada for most of the week. Like I said, hope you're all doing well. This is Samfiru Tumarkin's live Q&A Thursday evening edition. Welcome one, welcome all. We are here to answer your questions. Any questions related to your employment. If you're dealing with a difficult boss at work, if your employer is trying to change the terms of your employment and you have questions, if you've been terminated, if you've been let go for whatever reason, whether that's a temporary layoff, whether you've been let go and offered a severance package, or maybe you've been let go and you haven't been offered any severance whatsoever, we are here this evening up until 7:30 Eastern Standard Time to answer your questions. Really anything related to employment law. Paul Jones, unfortunately, so I can't help you out if you're in the US. But listen, for anyone watching, if you're having issues at work, do some research, find somebody locally in your area that can help you out. Even if you are in the US, you might have some rights, some protections that can assist you. Certainly in Canada and in Ontario, our employment laws are actually quite employee friendly and employee favorable. So again, if you're dealing with a difficult situation at work, whatever the situation is, you may have rights as an employee. You may have protections that you don't even know about. You might have options that you don't know about. So now is your time to speak with an employment law expert, speak with an employment lawyer, get some advice, get some questions answered, and certainly, you're in the right place to get that done. If you're a little bit too shy to ask questions online or on a live stream, there are a number of ways in which you can contact us. The easiest way by far to contact us is at our email address. And the email address is help@employmentlawyer.ca. That's help@employmentlawyer.ca. Send us an email with a brief description of your problem, brief description of your situation, and we will get back to you. I promise someone from our team will get back to you and put you in touch with an employment lawyer to assist you with your situation. The other way in which you can contact us is employmentlawyer.ca is the website, employmentlawyer.ca. Visit our website. We've got a ton of resources. If you want to do some basic research about your situation, again, whether you're dealing with a termination or a constructive dismissal or a temporary layoff or harassment in the workplace, employmentlawyer.ca. Look at our resources. We've got a ton of blog articles, a ton of news clippings, and you will get some basic information as a starting point to point you in the right direction with respect to your particular circumstances. I wanted to talk this evening, just to get the ball rolling and get us all warmed up, wanted to talk about the situation that actually came across my desk just today. A gentleman that I actually spoke with this morning, who was employed here in Ontario, was with the same company for about 4.5 years, and unfortunately was just let go from his employment in what he felt were very difficult circumstances. He was the general manager of a particular location for this employer, and some of his employees came to him with issues about the workplace. Now, these were kind of sales-related issues, and some of the employees had some gripes, had some concerns. He, as the general manager, felt that he needed to address his employees' concerns, and so he went to the owner of the company and voiced these concerns on behalf of his employees. The response from the owner was not what you would expect it to be. The response from the owner was that the owner actually terminated this gentleman's employment. So simply for raising these issues that his employees had, this general manager was terminated from his employment. And of course, he felt that that was incorrect. He felt like that was wrong because he didn't do anything wrong. He had actually very good performance, actually great performance within the company for over 4 years, and was let go simply because he brought this issue to the owner of the business. And I actually had some difficult advice for him. And what I had to tell him was, unfortunately, in those kinds of situations, an employer doesn't necessarily need to have a reason to let an employee go. You can be the best performing employee in the world. You can have a stellar record, no issues with your conduct or your character. An employer can still be allowed to let you go. It's what we call a without cause termination. A without cause termination is when there's no particular reason for the termination. The company has simply made the decision to let you go, in which case, of course, that employee is owed severance. But the reason for the termination, again, in this gentleman's case, whether it was related to the concerns that he relayed to the owner or related to any other reasons, the reason for the termination doesn't matter. It simply becomes a question of how much severance that employee is owed. And that doesn't always feel right. A lot of times, employees feel as though they might be able to get their jobs back, for example, and contest the termination or contest the reason for the termination. And listen, that may very well be the case if you're dealing with a human rights issue, if you're dealing potentially with a reprisal in the workplace. But in most cases, a without cause termination is strictly going to be about severance. The reason for the termination is very difficult to contest. And so, the good news in this gentleman's situation is that he is owed a significant amount of severance. He had been in a managerial position with the company and was with the company for about 4.5 years. He's probably looking at something like 6 to 8 months as a severance package, so a significant severance package. But again, part of the advice I had to relay to this individual was that, well, ultimately, you shouldn't be focused on the reason for the termination or the circumstances of the termination. You should be focused on the severance, simply because that's the way the law works. Now, I want to make it clear for you guys, that would not be the case if we were talking about, for example, someone who was on disability leave, or someone that had to be accommodated for medical issues in the workplace and is let go. In a case like that, certainly the circumstances and the reason for termination matters. You cannot terminate an employee based on a disability or based on any other protected ground under the Human Rights Code, whether that's age or religion or sex, etc., disability, of course. But again, in the ordinary course of things where those factors aren't in play, again, the reason for termination doesn't matter. It's really the amount of severance that's being paid that does. All right, I see a couple of questions coming up, so I will get to those immediately. James asks, I'm in Northwest Territories. Are you able to help me? Unfortunately not, James. If you have a question, listen, go for it. I can provide maybe some general advice that might apply to, across the country in Canada. But certainly if you are dealing with an employment issue in the Northwest Territories, you should certainly seek legal advice from a lawyer that's licensed to practice there. But like I said, feel free to ask away. And I'll do my best, and I can probably provide some general information and point you in the right direction. Carrie asks, you've been on medical leave since early 2020. Your doctors cleared you back to work. My employer hasn't responded to my emails and isn't giving me a return date. Is there anything I can do? That's a great question, Carrie, and it is something we do see from time to time. A lot of times employers will give employees returning from medical leave a hard time when they're ready to come back, and that's potentially a discrimination issue. Similar to the point I was previously raising, if you're ready to come back to work and you've been ready to come back to work and your employer is either ignoring you or not allowing you to come back, that is potentially discrimination under the Human Rights Code. It's also potentially a constructive dismissal, meaning you may be able to consider the company's ignoring you or the refusal to respond or to engage as a termination of your employment, as effectively a breach of contract. Now, Carrie, I want to be very clear. Before you resign your employment or email the company, anything like that, you need to speak with an employment lawyer. You have to be very strategic, very tactful about how you approach the situation. Give us a call or send us an email, again, help@employmentlawyer.ca. We would be able to walk you through a situation like this and give you the kind of play-by-play advice that you need. in order to either get the company to respond and get you your job back, or listen, if they're not going to respond, then you need to get out of there, get the severance that you're owed, and get moving on with your life. But you're right to ask the question, Carrie. An employer shouldn't be ignoring an employee who's coming back from a medical leave. They have to bring you back to work. They have to bring you back to work in the same job, on the same terms of employment that you left when you went on medical leave. And if your employer doesn't accommodate you, even if you can only come back to work in a limited capacity, or you have some restrictions about what you can and what you can't do, your employer has to play ball. They can't ignore you. They can't just brush you aside. And again, so you're right to answer the question, Carrie. You know, an employee who's coming back from medical leave actually has very, very strong protections when it comes to their employment. So if your employer is ignoring you, is giving you a hard time, do feel free to reach out to us. We need to have a chat, and we need to, again, either get you back to work or get you out of there with severance. Mike asks, can an employer terminate the employee with cause for not taking the vaccine if it's not an essential business? Great question, Mike. It's actually a question that we've been fielding lots over the past few months. Obviously, with the rollout of the vaccine, etc., this is something that has become kind of a hot topic. The short answer is this, Mike: no, your employer can't terminate you for cause because you're not taking the vaccine. There might actually be legitimate reasons why some employees aren't being vaccinated. There might be medical reasons, for example, why an employee is not able to be vaccinated. Again, you can't punish those employees. You can't treat them differently because they're not being vaccinated. And to answer your specific question, Mike, a with cause termination, for those of you watching that don't know what that means, a with cause termination is when somebody, an employee that is, does something so terribly wrong, so drastically against the employment relationship, that they're allowed to let that employee go. The company is allowed to let that employee go with zero notice and zero severance. You are literally kicked out the door that day because the company alleges that they had cause to terminate your employment. You have to do something pretty seriously wrong to be terminated for cause. We are talking about the worst of the worst kinds of offenses here when it comes to the employment relationship. Things like fraud, things like theft, physical abuse in the workplace, you name it. That's cause for termination. Not being able to be vaccinated, for example, to your question, Mike, is not cause for termination. And so there's no way that something like that is going to happen. This is a developing area of the law. We're probably going to see over the course of the next year, maybe 2 years, what employers will and won't be allowed to do when it comes to the COVID-19 vaccine. Of course, many people are going to get vaccinated, are happily going to get and willingly going to get vaccinated, and that'll be good for employers. Employers do have an obligation to maintain a safe and healthy workspace, and so vaccinations for COVID-19 may play a role in their obligations in that respect. But again, there are some limits to an employer's powers there. And so it might not be the case in many industries that an employer will be able to mandate a vaccine. Actually, in my opinion, and again, this is all developing, guys, this is all law that will probably develop over the next few years. But in my opinion, there might be a handful, if that, of industries where a COVID vaccine might be kind of required or mandatory. I can imagine hospital settings being one. There are some previous cases in which a flu shot becomes mandatory in the hospital setting for employees. And I can see the COVID vaccine applying similarly. And I guess another area that's been, over the news, in the news rather, over the past year, unfortunately, is long-term care homes. I can also see that as being an area where potentially a COVID-19 vaccine becomes mandatory. But again, I think those are the rare exception. I think in almost every single case, an employer won't be allowed to force you to be vaccinated, and also won't be allowed to terminate your employment for cause if you're not being vaccinated. Hopefully that helps. Mike, again, this is a novel area of law. This is all going to develop over the next few years, but I think you can stand by that advice. All right, guys, question from John. Can an employer provide a bonus or incentive for getting a vaccine? Great question, John. Again, this is all novel. So, I mean, there's no specific law or specific case, for example, that says yay or nay, that says yes or no. But what I can tell you is I wouldn't recommend an employer does that, at least in Canada. I know in the States, in some industries, this has been a kind of a mode of operation. Employers are incentivizing employees to get vaccinated. I probably wouldn't recommend it for any Canadian or specifically Ontario employers. There may be a problem there. There may be a semblance of discrimination there, again, potentially favoring employees that are willing to get vaccinated versus those that, again, probably or potentially at least through no fault of their own can't be vaccinated. Again, we're talking about people that might have medical reasons why they can't get vaccinated or even religious reasons why they can't get vaccinated. You can't favor other employees by incentivizing vaccination over those employees. That might be considered discrimination under the Human Rights Code in Ontario. So again, I wouldn't recommend it. John, I don't think it's a good idea. You can certainly, as an employer, express your opinion about vaccinations, have meetings about it, and give your employees access to information about vaccination. But I wouldn't go so far as encouraging employees to get vaccinated. It might send the wrong message to those employees that, again, through no fault of their own, actually can't get vaccinated. Lots of questions about COVID-19 vaccine, guys. I love to hear it because it is an interesting and obviously very relevant topic. Again, this is the employment law Q&A for this evening. We've got about 15 minutes left on the show, so please do not be shy to answer your questions when it comes to anything workplace related. We are here to take questions, to answer those questions, to help resolve your workplace problems. So again, do not be shy. Ask away. Now's the time. I am an employment lawyer. I've been doing this for many, many years now. This is the bread and butter of my work. And so you're in the right place. If you found us, you're in the right place to have your workplace questions answered. So again, fire away. Wanted to talk as well on my list of topics I wanted to touch on tonight, a recent case that came out of the Ontario Superior Court of Justice. So again, this applies to Ontario employees and employers as well. Actually, if you're a business owner or someone in HR or management that's watching this right now, this is going to be relevant to you as employer or management side as well. A case that recently came out of the Ontario Court of Justice with respect to temporary layoffs and COVID-19. In Ontario, you will know as an employee or an employer that last year the government introduced what's called infectious disease emergency leave. It potentially, and I say potentially for a very good reason here, it potentially in some circumstances allowed employers to put employees on this leave, on this emergency leave, which is effectively a temporary layoff, and have those employees sit at home, not collect a paycheck, not collect benefits, and effectively have to wait until they're called back to work or until this emergency leave ends. Lots of employees, correctly so, contested these temporary layoffs. They took issue with them. And the reason why they took issue with them is because a temporary layoff is actually a constructive dismissal. In other words, it can potentially be an actual out-and-out termination of employment. So employees that have been temporarily laid off can actually decide to treat their employment as permanently severed, obtain a severance package, and move on to new employment. A lot of employees actually made the decision to treat their layoffs as a termination because they felt that the layoff was unjustified. In a lot of cases, they were. Lots of employers were using the infectious disease leave, using these temporary layoffs as a reason to just send employees home, not pay them, and avoid having to pay off severance. Well, a case came out just 2 weeks ago now, confirming that a temporary layoff, even if it's due to COVID, is still a termination of employment. an employee is able to treat a temporary layoff related to COVID as a termination and obtain their full severance entitlements. So we now have confirmation from the Ontario Superior Court of Justice, from an Ontario court, confirming that these layoffs, these temporary layoffs related to COVID, or what employers might be calling, again, infectious disease leaves, we have confirmation that these leaves are in fact terminations and that employees are owed severance as a result. This is big, big news. This was actually a pretty hot topic of discussion within the employment law community. Lots of employers were, of course, taking the position that they were allowed to temporarily lay off employees because of the extraordinary circumstances, because of COVID, because of the changes in the economy. Lots of employers were wanting to temporarily lay off their employees. And we now have a case that says the opposite, that says that no, you can still treat these as, again, what's called a constructive dismissal, which is a termination of employment. In that case, the employee was found to be terminated and was paid a proper severance package, despite the fact that the employer was still calling it a temporary layoff. So very important stuff, guys. If you've been temporarily laid off and there's nothing that either contractually allows the company to lay you off, if you haven't necessarily signed anything that allows the company to lay you off, you can treat that layoff as a termination, obtain your severance entitlements, and move on. If you want to contact us about a temporary layoff, give us a call, send us an email. Again, help@employmentlawyer.ca is where to reach us. Employmentlawyer.ca is the website. You can find all of our contact information there. You can call us toll free. You can email any one of the lawyers, or again, email help@employmentlawyer.ca, and we will find you and get in touch with you. Garima asks, my employer terminated my employment with a letter saying you cannot support your payroll due to a lack of revenues. So you were not asked to come to work the next day, no notice given. Well, Garima, you're owed severance in a situation like that. The company may claim poverty. They may claim that they don't necessarily have enough money to pay you severance. And I'm assuming here, Garima, that you're in Canada, or at least ideally in Ontario. Just to be clear, I am an Ontario employment lawyer, so I can only give advice in Ontario. But in a situation where an employer is letting an employee go because of financial reasons, whether it's a restructuring or a slowdown in business, that doesn't change the severance analysis. It doesn't change the fact that that employee is owed severance. They are owed severance based upon their age, their position within the company, and their years of service with that company. And perhaps unsurprisingly, the older an employee is, the longer they've been with the same company, which basically means the longer they've been out of the job market, and the more senior their position is, or the more specialized their position is, the more severance they're going to be owed. It's going to be way more than just a week per year of service, or even 2 weeks per year of service. It's usually months per year of service. And so in a situation like that, Garima, you're still owed severance. If you are in either Ontario, British Columbia, or Alberta, we have offices in Ottawa, Toronto, Calgary, and Vancouver. Give us a call, email us at help@employmentlawyer.ca, and we will be able to assist you. We will be able to get you the severance that you are owed. We've got a couple of minutes left here, guys, so now is the time to get those questions in. As long as you're asking questions, I will stick around. So again, feel free to throw them my way. Wendy asks, I'm a nurse at a hospital for 23 years. You were sexually assaulted by a patient in 2012. I'm very sorry to hear that, Wendy. That's terrible. Ask your manager several times to remove the patient from the floor. You were assaulted in October as well of 2013. I've been diagnosed with PTSD, anxiety disorder. Do I have a case? If, Wendy, you are in Canada, I would be very concerned that you are probably out of time to pursue any kind of case. generally speaking, there is a 2-year limitation period on cases. And so if you had potentially a case against your employer in a situation like this where they did nothing in response to your concerns, and just to be clear, Wendy, and again, for all of you viewing out there, if you are concerned about your health and your safety in the workplace, you should be raising those issues with your employer, whether that's your manager or the owner of the company, whether it's a small business, a medium-sized business, or a large corporation. You have the right to be healthy and safe in your workplace. You should be bringing those issues to the attention of management. And if management does nothing about your concerns, that is a problem. That is potentially a violation of the Occupational Health and Safety Act in Ontario. It's also potentially a constructive dismissal, which we've been talking about throughout the show. It's potentially a breach of contract. It's potentially a termination of employment. The problem with your situation, Wendy, and I hate to say this, is that if this happened in 2012 and 2013, and we are now, 8 or 9 years later, generally speaking, there's a 2-year limitation period on these kinds of cases. And so this would have had to happen within the last 2 years. And again, if it had happened 8 or 9 years ago, you are probably out of time. You would have had to do something about it back then. So I hate to report, that news. To be sure, Wendy, you should probably seek legal advice wherever you are, whether that's Ontario or any other province in Canada or anywhere around the world. Really seek a local employment law expert, employment lawyer, to get you a definitive answer. But again, if you're in Canada and in Ontario specifically, there's a 2-year limitation period in these kinds of situations. All right, Athanan asks, one or two of the employees vaccinated and others don't want to take it. Whoever vaccinated doesn't want to work with them. How can I handle it? Okay, well, it sounds like you're dealing with the situation where some employees are vaccinated and some aren't, and there might be some kind of dispute about whether those individuals can work together. How I would answer that is you need to accommodate employees in the workplace if there are health and safety concerns. And again, if there are legitimate reasons why those employees haven't been vaccinated. You cannot punish an employee necessarily because they haven't been vaccinated. And so my advice, Athanan, would be probably to separate these employees and isolate the employees that either have or haven't been vaccinated. Again, you shouldn't be punishing them. You shouldn't be treating them any differently. But perhaps if some of them can work from home or work in separate, office spaces, that would be a solution to a situation like that. Now, again, I'm assuming that you're in Canada here, and specifically that you're in Ontario. There are going to be certainly lots of situations moving forward in the workplace where, again, the COVID-19 vaccine and whether or not employees have been vaccinated is going to cause issues. Employers should implement fair, practical solutions to these problems with employment law advice in hand. So if you're an employer in a situation like this, like Athanan is, you don't want to make decisions off the cuff. You don't want to make decisions without formal legal advice. Speak to an employment lawyer. Whether you're an employee dealing with a situation like this or the employer, you need proper advice in order to resolve these workplace questions. Otherwise, you are putting yourself at risk. Again, if you are an employer, you are exposing yourself and the business, the company, to liability. If you're not respecting health and safety in the workplace, if you are treating employees differently based on their vaccination status, that might be discrimination under the Human Rights Code. You need to know how to handle these situations properly. And the way you do that is to get employment law advice from an employment lawyer. If you are an employee dealing with a situation like this, again, you need to know what your rights are. You need to know what protections you have and also what obligations you have in the workplace. And the way you find that out is by speaking with an employment lawyer. And again, I'll put out our contact info one last time, guys. help@employmentlawyer.ca is the email address. employmentlawyer.ca is the website. Do feel free to reach out to us. I appreciate that some of you aren't comfortable asking questions on an online stream like this. If you have a question, there's something on your mind that's bothering you about your work, don't be shy to email us. It's completely confidential. There's no obligation. You will get a response, and we will be able to assist in some form or fashion. So don't be shy. Right under the line, Antonella, at 7:30 on the nose, you've asked a question, and I'm going to answer it. I've been with my employer 13 years, a senior manager, and they are hiring a director to do your job. 3 departments reporting to you, and they want to take them away and change your duties. Do you have to accept these changes? If I find another job, do I lose any severance? Great question, Antonella. The crux of the issue here is whether these changes are fundamental or significant or substantial. Those are the terms that the law uses in these situations. And if these changes are significant, if they are substantial or fundamental, and they sound like they are, quite frankly, at first glance, if you are losing all of your reports and they are being taken away from you, and your duties and your job responsibilities are changing in a significant way, that is a constructive dismissal. It's effectively a breach of contract or a termination of employment. And so, again, before you make any decisions, before you say that to your employer or accept the change or respond in any kind of way, you need to speak to us. So again, help@employmentlawyer.ca. Send us a quick email. We'll be able to reach out to you, get you set up with an employment lawyer, and get into the nitty-gritty of your situation. To answer the second part of your question, Antonella, if you find another job, do you lose your severance? No is the answer, as long as you get the severance negotiation and settlement wrapped up before you find that next job. Remember that the point of severance is to hold an employee over until they can find new work. And so if you find a new job before you've resolved your severance claim, and heaven forbid your employer, your ex-employer, finds out the fact that you're working again, you lose all of your leverage as an employee in a situation like that. You lose all of your ability, or probably a big portion of your ability to negotiate a severance package. So you want to resolve the severance claim first, and then go out and find a new job. And if you do, if you wrap up that severance negotiation and you sign the paperwork and it's all done and dusted, you can then go out and find the job the next day. It won't affect your severance. Thank you all very much for watching. This has been an excellent Thursday evening edition of the Employment Law Q&A. Again, my name is Alex Lucifero. Samfiru Tumarkin LLP is the firm. Thanks again for joining us. Employmentlawyer.ca is where to find us. I'm slamming my desk here. I'm so excited. Do tune in next time. We've got a Facebook Live coming tomorrow. That's Friday, May 21st at 1 p.m. Eastern Standard Times. And we do these all week at different times of day. So tune in. Until next time, hope you all have an excellent end of the week and great weekend. We'll see you all soon.